Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
All right, welcome to the FloridaDefense.com podcast. We are speaking to St. Petersburg drive-by shootings attorneys, Bauer, Kreider, and Perry. It's also Pinellas County, correct? St. Petersburg, Mike?
That's right.
All right, and then we're speaking to attorney Mike Kinney. Mike, let's talk a little bit about drive-by shootings today.
Sure. Drive-by shootings, I guess the way most people understand them is it's a crime where a person fires a gun while they're in a vehicle and potentially driving by a location. So Florida has designed a couple of statutes that specifically try to address that scenario. There isn't a drive-by shooting crime per se, right? Shooting at somebody is a crime. Killing somebody is a crime. So those kind of take care of themselves. But they do have some shootings, some crimes that involve shooting from a car or into a car. One of the crimes that Florida has is discharging or shooting from a vehicle, discharging a firearm from a vehicle. So if you're inside a car and you shoot and you shoot from a car, there's a specific statute that addresses that, and that's a felony that's actually, because there's a discharge of a firearm, carries with it a pretty significant minimum mandatory prison sentence. And then there's shooting into an occupied vehicle, which can happen whether you're standing on the street and a car drives by and you shoot into it, or you're in a car and you shoot into another car, if you can imagine that scenario. So that's designed to address, people who are being victimized while they're inside of a car. And there's a scenario where you can be in one car and shoot into another car, and you get charged with 2 counts, shooting from and shooting into. A lot of times you see people in cases, I've had cases where a person is charged with discharging a firearm while shooting from a vehicle and into a house, because shooting into an occupied dwelling is another category of crime. So the way the legislature has done it, they've kind of gotten specific scenarios that all seem to address that issue that apparently was a concern about people basically exploiting opportunities to shoot people by surprise without them being aware of it. So the penalties are significant, like I said, because they involve Florida's 1020 life statute. And the 1020 life statute is specifically going to give you a 20-year minimum mandatory prison sentence if it's been found that you have discharged a firearm. Mere possession of the firearm is a 10-year minimum mandatory sentence. And obviously, if somebody gets hit and seriously injured or killed, a person can get 25 years to life. And oftentimes it's life for these type cases. And the unique thing about Florida is that they kind of have catch-all crimes to begin with. Any one of these things that we just described could easily fit the category of an aggravated assault with a firearm or an aggravated battery with a firearm. But a discharging from an occupied vehicle is just more. It has a little bit more to it, a little bit more teeth to the charge. For instance, an aggravated assault with a firearm without discharging it, while it's significant, is a 3-year minimum mandatory prison sentence where you get 20 years on one of these shooting from an occupied dwelling type cases. And like I said, I've been involved in plenty of these cases, and they obviously come up in situations where a lot of times there's witness issues and not everybody knows even who it was or where it was. So a lot of times it's piecing these things together by the physical evidence and the forensic evidence. What I have found to be an issue a lot of times is these crimes often come in when they're involving occupied vehicles by more than one person. And the idea of getting law enforcement to be able to say who the exact shooter was isn't always that easy. They try to do an investigation and piece it together. And some things that they use are, gunpowder residue tests, obviously witness statements and witness testimony. But these things happen so fast sometimes that it's not always that easy to have reliable witness information. I've been involved in plenty of these types of cases, both as a prosecutor and a defense lawyer. And it's very important, probably from the law enforcement perspective, to kind of figure out who is involved very early on and try to have contact, because as time goes on, things get, I think, much harder for them to piece together a case, especially if the evidence isn't always going to be there anymore, as far as the firearm or the residue, the gunpowder residue, gunshot residue tests that they perform on people's hands to show whether or not they discharge a firearm. But that's, as far as drive-by shootings in particular, those categories are really the categories of crimes, that specific types of crimes that kind of encompass that drive-by shooting scenario, and that pretty much wraps it up.
All right. You've been listening to the FloridaDefense.com podcast. You can check them out online. Bauer, Kreider, and Perry. We've been speaking to Mike Kinney.
Thank you for listening to the FloridaDefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit FloridaDefense.com today.